After discussing labor standards, we will now go to labor relations. So this part of the study of labor code will give us the picture wherein the employer and the employees are actively interacting, where the employees demand for higher terms or better terms and conditions of employment through collective bargaining negotiation, and on the other matters, the employer actively exercises its management prerogative to discipline and terminate employees. So this study of labor relations deals with the active interaction. So as what I mentioned to my students, there will be action here. This is the action portion of the study of labor law. And before going to the details of the other topics or major topics in labor relation, we have to start with the concepts of employer and employee. The reason why we have to start with these two concepts is because if there is no employer-employee relationship, then the labor code will not apply. So the labor arbiter will not have jurisdiction over the case in the absence of employer-employee relationship. Okay, now let's start with Article 209, paragraph E of the labor code. It defines the concept employer. Now, who is an employer? Using this article, the word employer includes any person. As a law student, you know the meaning of person. Natural or juridical. Natural, determined by birth. Juridical, determined by creation through a law. Now, this person is acting in the interest of an employer. Now, what is the interest of an employer here? First, the employer hires employees to protect a particular interest. In the case of private sector, the employer hires employees in order to advance its business, in order to have profit. On the other hand, you also have the government. Any instrumentality or agencies of the government, which is not for profit but for service, also hire employees. So the interest of the employer varies. If the employer is in the private sector, then the interest would be hiring and protection of its business and expansion and to have profit. On the other hand, if you are in the government sector, except those government-owned and controlled corporations which are engaged for profit, the objective here is to carry out the mandate of the Constitution. That would be delivery of basic services. And you know for a fact that even if you are government, you cannot deliver basic services without hiring employees. So you have different government entities hiring employees. We also consider them employers. But for purposes of the labor code, the labor code doesn't apply to that kind of relationship because it is governed by another law. We are talking of the administrative law, and the court that has jurisdiction would be the Civil Service Commission. Now let's go to our discussion of employer in the private sector. So you know already when the employer is acting in the interest of an employer in the private sector, it hires employees in order to protect its business, to have more profit, to expand, and other objectives of doing business. What do you mean by acting in the interest of an employer directly or indirectly? In the case of private sector, employees who hire directly employees are directly acting in the interest of an employer. However, there are other employers who don't directly hire. they use some other entities. Like for example, labor-only contractors. So they hire labor-only contractors in order to provide them employees. So they are acting indirectly. Under the law, if it is a labor-only contracting, then the employer here or the principal hiring the contractor shall be considered the employer. Now the second thing that you will remember is that the word employer does not include labor organization. However, there is an exemption if the labor organization is acting as an employer. What do you mean by that? When the labor organization is hiring employees to do its operation. In that case, then the union or the labor organization becomes an employer. That is the case of Haveria versus Social Security System et al. August 22, 2019. So you know already when an entity is considered an employer. Now, who is an employee under paragraph F of Article 219? It is defined there that an employee includes any person in the employ of an employer. So any person, we are talking here of natural persons in the employ of the employer. They are hired. I always emphasize that the word employee here must refer only to natural persons, not juridical persons, because the natural persons are object of control as to how the work will be conducted as well as the end to be achieved. However, there is a qualification here when we go to the second paragraph, that the term shall not be limited to the employees of a particular employer unless the code so explicitly states. What do you mean by this second statement? So it means that you can still be considered an employee even if in initial or in the preliminary evaluation you are not my employee, but the labor code explicitly states if we are going to use a legitimate job contractor. A legitimate job contractor provides employees to the principal. If this legitimate job contractor is engaged in labor-only contracting, which happens in many instances, then the labor code explicitly states that it becomes the agent of the principal. Therefore, the employees hired by the contractor will be considered the employees of the principal, if that is the case of labor-only contracting. If it is a legitimate labor contracting, or the entity involved is a legitimate job contractor, then the labor code provides that the employees of the contractor are not employees of the principal. So this meaning will apply if there is an entity or a third party involved. So there is an agency or a contractor hired by the principal. Now another sentence would be the inclusion of individuals whose work have ceased as a result or in connection of any current labor dispute or because of any unfair labor practice, if he or she has not obtained any other substantially equivalent and regular position or employment. What do you mean by this? So you are still considered an employee if you are terminated, if your employment has ceased because of a labor dispute or unfair labor practice, provided that you have not obtained any other substantially equivalent and regular employment. Of course, you know the meaning of these individuals who are terminated because of a labor dispute or unfair labor practice. The question now is, what do you mean by who has not obtained other substantially equivalent and regular employment? It means that while the individual has ceased his or her employment, normally the individual will find another work or job. If that individual finds a job which has lower salary and the status is not regular, even if the individual is employed with another employer, then he or she is still considered employee of his former employer. What will happen if the individual whose work is terminated because of labor dispute or unfair labor practice has obtained a substantially equivalent and regular employment? Then, from the time of employment with his or her second employer, he or she is deemed to have impliedly resigned. So she could not be considered, or he could not be considered, as the case may be, an employee of the former employer. In relation to this illegal dismissal thing, you have to remember that the employee has 4 years from the date of termination to file an illegal dismissal case. So therefore, even if the employee who has ceased to be terminated, as long as the 4-year period has not prescribed, then the employee is still considered an employee. Because we do not know that on the 3rd year or even after 3 years and 11 months, the employee filed an illegal dismissal case. Assuming that the employee will win, there will be award of reinstatement and back wages. So you have to remember that one. So we have an instance where the employee was terminated, and there was, while the case was still pending, there was this certification election in the bargaining unit. The employee, for all intents and purposes, still considered an employee of the employer, and therefore is entitled to vote.